Hello students, welcome to the paper titled Legal Theory Jurisprudence, Module 14, Module Name, Custom, Importance of Customary Law, Kinds of Customs and Essentials of Custom. Outline. The customs in this module would include Introduction, Importance of Customary Law, Kinds of Customs and Essentials of Custom. Learning outcome. At the end of the module, the student will be able to understand jurisprudence in its proper sense with the help of customs as a source of law. As it is one of the oldest sources of law, the perspective it provides in the study of law is noteworthy. It comprehends the meaning, importance, implications and application of the concept by unearthing the topic in detail. Introduction. Customs play a pivotal role in regulation of human conduct in practically all societies of the world. It is one of the oldest sources of law. Customs have been defined by Dias in following words: a continuous course of conduct which by the acquiescence or express approval of the community observing it has come to be regarded as fixing the norm of conduct for members of the society. Unquote. With the growth and development of legal system, the prominence of customs is seen to be slowly diminishing. The importance of custom on society is similar to that of law on state. Students, we have another important definition at this juncture. Dr. Ellen defines custom as the uniformity of habits or conduct of people under like circumstances. The next definition that we will see is that of Salmon. Salmon opines that customs embodies those principles which are acknowledged and approved not by the state but by the public opinion. Importance of customary law. Prior to the development of the state, the only form of law that governed the conduct of people was customary law. Subject areas like succession, marriage, adoption, etc. were regulated by the customary law. It is not always necessary that the courts should recognize all the practices which are prevalent in the community as custom. These are also popularly called as conventional customs. They are established by long usage. Certain customs are binding and are enforceable by a court of law since they are backed by the sanction of the state. It involves two conceptions. Firstly, the faith or conviction, and secondly, the constant use. Custom has also played a prominent role in the development of international law. Kinds of customs. For the existence of a customs, it is not necessary that a custom should be practiced all over the country. A certain custom may be practiced only in a particular society. It is important to note here that customs can be broadly categorized into two main types. Firstly, conventional custom, and secondly, legal custom. First one, conventional custom. It is also referred to as usage. A conventional custom is legally binding not because of any legal authority, but rather because it is incorporated by parties to a contract. Development of conventional customs involves three stages. Firstly, it must have usage. Second, the recognition through judicial decision. And lastly, If it clears the first two stages, then it is accepted as third stage by codification. It should be noted here that a conventional customs may be of local or national type. To acquire the status of law, the following 4 points need to be satisfied. Firstly, it should be old enough to be in the knowledge of people in general. Secondly, it should not be contrary to the general law of the country. Third point that we should note here is that it should be reasonable. And lastly and importantly, it need not be confined to a particular area. The second category is that of legal custom. Legal customs operate as binding rules of law. They are independent of any agreement between the parties. They can be further classified into two types. Firstly, local custom, and secondly, general custom. The first category, local custom. Students, a local custom prevails in a particular society, whereas a general custom is prevalent throughout the realm. It is also important to note at this juncture that a local custom to be valid should be of a certain type. It should be reasonable in nature. Its practice should be continuous in time. It should be permanent in its usage, and most importantly, it should not be contrary to any existing law prevalent at that particular time. The next category is that of general custom. This particular point prevails throughout the realm and is also known as a source of common law. Some of the examples that we can note here at this juncture are that of Hindu law and Hindu Succession Act. It is also important to note at this point that a general custom is usually practiced by all the people living in the country and is prevalent throughout the land. Essentials of a custom. In order to qualify as a valid custom, it must conform to certain requirements. They are as follows. First one, reasonableness. A general observance of custom leads to the presumption that it has a rational basis. Consistency. A custom to be valid must be in conformity with the statute law. Thirdly, compulsory observance. A custom to be legally recognized as a valid custom must be observed as a right. Continuity and immemorial antiquity. A custom to be considered as valid should have been continuously in existence from times immemorial. If anyone can show the beginning of a custom, then it is no custom at all. Certainty. In order to prove the existence of the custom, there must be presence of element of certainty. A custom should not be opposed to public policy. References. Students, these are some of the references for your perusal. Thank you.